Hey everyone, it's Professor Morris, and welcome to another lecture in our cannabis course, our CCJ 2760 Cannabis Law and Regulation course, where we are going to be talking today about the Fourth Amendment. I had, I think, spoken about this previously when we were going over legalization versus decriminalization in a short lecture I had recorded for you last week. This week, we're going to kind of elaborate a little bit more on the Fourth Amendment, go over it in a little more detail, talk about what police officers are doing when they are stopping you in a vehicle versus when they are trying to obtain a search warrant at home, and what those limitations are, especially when it comes to cannabis, marijuana, and of course any other illicit substances that, again, I certainly don't condone or endorse in this class, but I also know that life happens, and sometimes you have friends who get into certain things that you may or may not know about, and you need to be aware of what these rules are for your own protection and for the protections of your friends as well. I don't want you to make it a habit of giving legal advice to your friends. In fact, everything I'm going to cover in today's course in today's lecture is not legal advice. This is common knowledge you can look up on your own. And I always say that simply because I'm your instructor for this course. I cannot be your attorney. I am not here to be anyone's attorney nor give anybody, again, legal advice that they can actually use if they find themselves into trouble. However, again, it's important to know these rules so that you can make your own decisions based upon what you want to do and not do when it comes to operating a vehicle, interacting with police, or how to conduct yourself during a traffic stop, because all of those things can be super important. And there are lots and lots of videos online, by the way, from attorneys who are marketing their services who do these kinds of videos. So, this one obviously is geared more towards this course, but you can certainly find other probably better explanations of the Fourth Amendment and how it works from attorneys who are, again, trying to get you to hire them for a particular legal case if you ever need help in the future. In fact, I'm going to actually link to some of those videos, at least one of them that I thought was interesting, about a marijuana traffic stop involving marijuana and marijuana paraphernalia. And even though it's in a different state, the constitutional rules apply when it comes to the Fourth Amendment. So you actually will get a chance to watch one of those videos as part of this week's course lecture. I'm not going to give you as much written material to read, even though you can certainly find a lot on the Fourth Amendment and searches and seizures. And for those of you who are future police officers who are taking this course, I highly recommend that you wrap your brain around how the Fourth Amendment works. And for those paralegal students out there, I hope that you also, especially if you're going to start working or want to work for a firm that represents criminal defendants, Fourth Amendment issues are going to come up all the time. It is a common defense that defense attorneys make, and I'll explain why in a minute. And for all of you other students out there who are just curious about cannabis law and regulation, or becoming a paralegal, or maybe even becoming a police officer, these rules are important to you, and the Constitution is important to all of us because these things apply to all of us, whether we are engaging in any type of illicit activity or not. These rules apply to all of us. And so whether you're stopped for speeding or if you're stopped under suspicion of something else, all of these rules still apply, and you certainly should take those things into account as you move forward. So real quick, let's take a look at the Fourth Amendment and actually what it says, what it actually does when it comes to our rights and how they work, and what you, again, should come away with when you read it. So what I've done is, this is the Fourth Amendment in its full entirety. It's pretty short, as you can see. And I've obviously bolded and italicized some specific buzzwords that I want you to kind of remember and keep track of as we move forward with our scenarios. So the Fourth Amendment reads, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly described the place to be searched and the persons or things to be seized. And that is it. That is the Fourth Amendment in a nutshell. And again, the buzzwords that you really want to kind of keep a track of and hone in on, being secure in their persons, houses, papers, and effects. Basically, what that means is no matter whether it's your person, your body, your home, papers that belong to you in your home or that are in your pockets or in a book bag or backpack that's attached to you, and effects. And that's what it means by effects is, say you're carrying a briefcase. Well, even though that briefcase isn't necessarily part of your body, because you are holding it, it is technically under the Constitution part of your body. And so the police can't search it without either your consent or without some type of probable cause. We'll get to probable cause in a second. And again, another word I want you to kind of be aware of are the words unreasonable searches and seizures. Sometimes you'll hear illegal searches and seizures. Sometimes you'll hear unauthorized searches and seizures. What they are basically talking about is our Fourth Amendment rights and unreasonable searches and seizures. These are searches and seizures that if a court, if a judge finds that a police officer violated your rights or a criminal defendant's rights when they conducted a search or a seizure, that means they took the person and said, you can't go, you're not free to go, you have to stay here, or they tell you to turn off your car and step out of your vehicle. At that point, again, you are being seized by the police. You are not free to go. If you tried to leave, they would come chase you. They weren't going to just let you drive off and say, oh, okay, he's not interested in playing ball with us, so we'll let him go. No, they're going to go find you. And once they do find you, they're going to charge you with a crime. And it could be anything from obstruction of justice or obstructing a police investigation to evading police. If it turns into a high-speed chase, there could be even other legal ramifications. So again, when a police officer tells you you are not free to go, you have been seized. And if it involves your property, and your property, you're not free to take it with you when you go, that property is also being seized. So a search is obviously when the police want to look into something or look at something in more detail. A seizure, again, can be anything from seizing you from being unable to freely walk away or drive away on your own without being followed. And it could mean also a seizure of your property, where they want to hold on to your property as evidence or potential evidence against you in a criminal case. You're not free to go down to the police department and pick it up unless they release it to you after the case is completed, or if it's been dismissed and completed. Either way, you're not getting your property back unless they give it to you. So it has too been seized. So unreasonable searches and seizures are the language used to describe any violations of Fourth Amendment rights. So any of those personal rights to your body, your home, your papers, your things, all of that cannot be violated, and no warrants will be issued without, and these are the two most magic words, if you will, in this constitutional amendment, and that is probable cause. Probable cause. What is probable cause? Well, again, you police cadets will certainly know what probable cause is. It is either reasonable or articulable suspicion that a crime is being committed or has been committed. Reasonable means that if I took a reasonable person off the street, i.e. a jury member, and I said, hey, do you think it's reasonable for this police officer to believe that a crime was committed in this case? And I give that individual certain facts. that reasonable person would then say yes or no. And that is the definition of reasonable. It is whatever a reasonable person would believe. Now, when it comes to articulable suspicion, that is a police officer's ability to explain, normally under oath, why they believe a crime either was being committed or had been committed. I smelled marijuana coming from the car. I smelled alcohol on the driver's breath. I saw the suspect running from the home with a television set on his shoulder as he rushed to his car. That is a way for a police officer to basically say or articulate that he or she believes a crime has been or is being committed. So if a police officer can reasonably explain and can articulate clearly under oath in most cases that they believe reasonably that a crime was being committed, then you've got probable cause. And probable cause, again, can be usually anything a police officer can see, smell, hear, and you can usually take taste out of it. But again, those other senses usually come into play. Sometimes touch. If there's maybe the person said that they left their home at a certain time, and the officer kind of places his hand over maybe an oven in the kitchen and it's still warm and it doesn't jibe with the time frame that the witness gave them. That may be something that they can use as part of their probable cause. That's kind of a reach. But usually, again, it is based off of what is known as the plain sight doctrine, which is anything they can see, hear, or smell. And again, I saw the driver had bloodshot eyes that were glazed over. I saw that I smelled that the driver had alcohol emanating from his breath when he spoke. I heard someone pounding on the trunk of the car who was trapped inside, which gave me a reasonable suspicion to conduct a search of the vehicle and to apprehend the individual first, then conduct a extensive search of the vehicle. So again, anything they can see, smell, or hear is usually part of that articulable suspicion, which gives rise again to probable cause. And when it comes to warrants and search warrants, we'll talk about oaths and affirmations a little bit later when we talk about search warrants and searches of homes. But an oath is obviously that's when you swear under oath to a judge when you are applying for a search warrant, which is how search warrants are created and obtained by police. Is they have to go before a judge or they have to provide documentation to a judge who then looks at it or talks to the officer under oath, and basically the officer explains to them, articulates to the judge why they believed they thought probable cause existed and they need to conduct a search of that home. And the only way to get inside that home is with a search warrant. And so the officer will have to explain to that judge under oath, or again, through forms that will have that fancy language at the bottom, sort of like the language I provided on that identification affidavit I provided you to sign that says basically under penalty of perjury, ... That is affirmation. And again, this is where the term affiant comes from. And you're affirming to something. This is where the term affidavit obviously comes from. It is an affirmation of something that the person who is signing that document believes to be true. And in the case of search warrants, it's usually some type of form that the court has that the officer will fill out and write in the facts of their investigation and then provide that under, again, with signing under penalty of perjury, that anything they tell that judge has to be true. If it's found later to be false, and yes, this does happen, where police provide false information to the court to obtain a search warrant, that obviously can be challenged later in court. And if that search warrant is invalidated by the judge, that entire case and all of the evidence that was obtained pursuant to that search warrant can be excluded under what is known as the exclusionary rule pursuant to the fruit of the poisonous tree doctrine, something I alluded to in our last video. We will get into that in a little more detail in a second. And again, when it comes to search warrants especially, they have to basically list with particularity, with detail, the places to be searched and the persons or things to be seized. So it can't just be a search warrant that says you have the right to search the home at 251 Jones Street. You're not going to get very far with that because it's got to have details. Not only is it 251 Jones Street, but it's everything inside the living room, the bedroom, the dresser drawers, the closets, the attic. If it's got a cellar, the cellar, any back door or back area patios or sheds. Anything on the property has to be listed in that search warrant as being part of a valid search. And if that individual violates that search warrant or lies to the police in obtaining that search warrant, then all of that evidence can be excluded under the exclusionary rule, and that can be dismissed. That leads to an easy dismissal for a criminal case, and that can be a real problem if you, again, are a police officer or an investigator of some type, and you are giving bad information to the police or to the courts in order to obtain a search warrant. So you really want to avoid that. So again, Fourth Amendment, reasonable searches based on articulable or reasonable suspicion, and that gives rise to probable cause, and that is where we are with regards to the Fourth Amendment. So let's quickly talk about what it means when you violate the Fourth Amendment. There is something known as the fruit of the poisonous tree doctrine, which is a doctrine I love. It's a great metaphor, and it basically means that if the roots of a tree are like the roots of an investigation, and the base of the tree is got that poisonous that poison kind of flowing through it to the leaves and also to the fruit, which again kind of plays the role of evidence in this metaphor, then any evidence that is obtained illegally is, if the investigation or the roots of the investigation are illegal, then any fruit derived from that investigation is also illegal, and that can be a real problem when you get to the exclusionary rule, because if a judge believes that a police officer conducting an investigation conducts one improperly or unreasonably in violation of that individual defendant's Fourth Amendment rights, then any information that is obtained from that unlawful or unreasonable investigation can be excluded as evidence in that case, and that can lead again to a dismissal of that case, and that is a real problem. So fruit of the poisonous tree is the doctrine that we are talking about here, and again, it all basically applies under what is known as the exclusionary rule, which is the right of a judge to exclude specific evidence that has been obtained improperly, unreasonably, or illegally based upon, again, in a violation of the criminal defendant's constitutional rights. So the fruit of the poisonous tree doctrine is huge. The exclusionary rule, again, is huge in criminal defense cases where you will often have a judge ruling up or down, thumbs up or thumbs down on the validity of the evidence that is being collected and whether or not it is being collected in violation of a particular criminal defendant's constitutional rights, and that can be a real problem. So let's then look at this idea of police stops, and that is any interaction that you're going to have with police when it comes to basically a traffic stop. And this is something, and again, this comes from a video that I'll probably show you later on in the course, but this is just a still to kind of give you an idea of why a police officer will stop you and why they love asking you when they stop you. They shine that light in your eyes and they ask you, do you know why I stopped you? And of course, police officers really don't care whether or not you have a good answer as to why you stopped them. It is more to, again, conduct a criminal investigation of the driver,
when they ask that person a question, they expect an answer. And when that person responds, they are smelling that individual's breath. They are looking into their eyes. They are seeing if they are, glassy or bloodshot, whether the pupils are dilated, all signs, physical signs of either intoxication or some type of misuse of substances while driving. And that can be a real issue, obviously. DUI is a big problem for many young people, and so is smoking under the influence, and that is obviously driving while high on marijuana. So drivers need to be very careful to avoid these types of problems. And again, when a officer is conducting a search or a traffic stop, that can be a real problem for the driver if they don't know, again, what these rules are. And that means that basically, yes, you can tell an officer, no, you cannot search my vehicle. They love to ask you that question again. Do you know why I stopped you? Doesn't really matter what you tell them, as long as you're sober and cogent and not causing any problems or giving the officer any reasonable reason to believe that you're under the influence or that you may try to evade the interaction with the police officer. Again, you want to stay calm. You want to make good eye contact. You want to be polite. Officers, as you know, with traffic stops, and those of you who are in police training, you know this too. A traffic stop is one of the most dangerous times for a police officer. And so many officers, again, are going to be maybe a little bit nervous, a little concerned. And so your job as the driver is to get out of that interaction without any issues. And that means treating the officer with lots of cordiality, being respectful. Don't get angry. Don't get upset. Certainly don't get rude or offensive. Don't wave around your hands a lot. That officer is watching you, making sure that you are calm, cool, collected, and that hopefully you're going to get out of that whole interaction with just a warning, and they're going to let you go. But what they cannot do is they cannot keep you there but being free to leave the interaction with the officer if they have no other reason to basically seize you or your vehicle. So it is okay to ask an officer, hey, am I free to go? And if they say yes, obviously you're free to go. If they say no, you continue to play it cool, but let the officer once again know, am I free to go? Can I leave? And usually because of the 2015 Rodriguez case, which basically was a U.S. Supreme Court case that said that police officers cannot maintain or seize an individual or the vehicle for over an extended period of time without writing a ticket, if, again, there's no other probable cause to believe that that individual committed any type of violation. So again, it is free to ask an officer if you are free to go, or am I being detained, or am I free to go? And again, I'll present a video on some of these rules, again, probably better explained than I can, about what to do and not to do with regards to particular traffic stops. So be super careful when it comes to Fourth Amendment, but also know that you do have the right to refuse searches, especially anything an officer cannot see inside of, i.e. a closed compartment in the center console of your vehicle, a closed glove box or glove compartment. Again, police officer can't see inside that thing. They cannot compel a suspect to open either a trunk or a glove box without the driver's consent. Now, officers will sometimes make it feel like you're not being asked. They may say, you don't mind if I open your trunk, do you? Or you don't mind if I look in your glove box, do you? Again, it's a little more affirmative, but again, you can say as legally as possible and as politely as possible, I don't consent to searches, and no, you may not search my trunk or any other part of my vehicle. And again, that officer then, if the ball is in their court, they then have to decide on what they want to do. And normally they will simply either write you a ticket, write you a warning, send you on your way, and you're free to go. But if you respond calmly and again, you maintain some degree of diplomacy, you can likely drive away from this situation without any other issues. But you do need to be careful, and you do need to, again, make sure that you don't escalate the situation by making it worse, by losing your cool, getting impatient, or again, scaring the officer who's investigating your vehicle or you, because again, they can make things much harder. And again, you want to kind of, it's okay to assert your rights. It's okay to protect your rights. I certainly encourage that. And you can do so politely by simply saying, I don't consent to searches ever. And no, officer, you may not search the trunk of my car. Or no, sir, you may not search my glove box. Or I am not consenting to any search. That's all you have to say. And if they violate your Fourth Amendment rights, you're a defense attorney. If you're arrested and you have to go to trial, or even a pre-motion hearing where they're trying to get evidence obtained against you to use against you in court, you can fight that, and your defense attorney will fight that. It's one of the core defenses that defense attorneys do use in criminal cases, which are Fourth Amendment defenses, where they will claim that the police violated the defendant's Fourth Amendment rights with an unreasonable or illegal or unauthorized search or seizure. Again, either descriptor will work. Another thing that I want to quickly go over are search warrants when it comes to homes. And again, I'm going to try and break this down a little bit. As you can see, I got these stills from videos, and I just like the layout and the sort of image to use. And I couldn't find an image that I could use for this course, and in particular this lecture. So this is a really nice kind of aerial view of a home, and as you see, it's got really well-defined property lines. That's another reason why I kind of like this particular video still, is because this is going to be the imaginary house in our search warrant lesson, and I wanted to again have a home that's got some well-defined property lines, because there are a number of cases, even in cases here in Florida, that have involved search warrants in homes and the searching of garbage, which is a very common way the authorities are able to track down people who violate the marijuana and cannabis laws in Florida. And that is with regards to, especially when it comes to the intent to distribute or to buy or sell large quantities of marijuana. So when you have a case like this, and let's say the individuals inside this particular home, and again, this is not a actual home in a real legal case. This is just an aerial photo that I found that I kind of like because it comes from a video still, and it's got some, again, well-defined property lines, especially the one in front of the road, which is what we're going to concentrate on. But when police do a stakeout, this is prior to obtaining a search warrant to go inside the perimeter of the home. And this is, again, involving any criminal investigation where property or a home is involved. Instead of a probable cause, you're going to need a search warrant. The authorities will need a search warrant in order to search a home or a particular piece or plot of land. So we've got this home, again, pictured here, well-defined property lines. When police are going to conduct a search, they will often they will basically scout out a particular area of the home. They will monitor the home in many cases to monitor who goes in and out of the home. They will monitor, they will sometimes keep track of the license plates of vehicles that come and go from the home. They will monitor if people are bringing large bags inside or leaving the home with large bags. Again, these were all kind of telltale signs of drug trafficking, and police are looking, again, for a articulable reason or reasonable suspicion that will give them rise to probable cause that crimes are being committed inside this property, that will allow those officers then to go before a judge in a courtroom under oath and basically swear why they believe under oath that there are crimes being committed inside that home. And sometimes the officers will conduct what's known as a stakeout. Many of you already know what those are, where they will kind of station themselves right outside the property line. Maybe over here, this home is adjacent to a golf course, which gives plenty of open land to individuals who might want to kind of do a stakeout here in this little shrubbery area, just east of the home, assuming that true north is to the north based on the configuration of the home's property. And then, of course, you've got this next door neighbor over here on the west side of the home. That may be a good place for police to do a stakeout where they can observe from inside. It's easy to conceal themselves. And again, they can conduct that search, and as long as those searches give the officers enough reasonable suspicion, they can include in a sworn affidavit as to why they believe drugs are being bought and sold from either inside the property, or they're using the home as sort of their headquarters to buy and sell drugs. Then that obviously is what the police would need when they are explaining in their affidavit their affirmation as to why they believe they have probable cause for crimes being committed in that home or near that property. And what we're getting to then is a case involving, and this has been adjudicated in numerous jurisdictions, including Florida, where the police will basically look through people's garbage. And the key thing that I want you to remember when it comes to garbage cases and searching garbage is something known as a reasonable expectation of privacy. A reasonable expectation of privacy. And again, this has to do with Fourth Amendment rights, where the police want to search a particular home. And again, they want to search maybe things that are connected to that home. And quite often, when someone will leave their garbage out here, let's see, again, pointing my cursor down at the driveway where someone might leave garbage normally, even if it's in one of those black sort of rolling canisters that they use here in North Florida for garbage collection. Those, again, you can't see inside them. So you would think that an owner of one of those, even if the dumpster were on their property, might have a reasonable expectation of privacy to the confines, to the things inside that garbage disposal or that garbage bin. Well, it really depends, because there's been case law that has stated that essentially when people leave garbage out to be collected by the garbage people, by the garbage company, or whatever private entity collects garbage in your area. Sometimes it's run by the city. Sometimes garbage collection is run by private corporations. And the bottom line is, courts have ruled that when a person leaves their garbage out on the side of the road to be collected by someone else, and that includes garbage that are in those large black rollable canisters. Again, if you're not in Florida, you may not know what I'm talking about. I'll put a picture in the lecture, but it's certainly an opaque device for collecting garbage and rolling it out to the corner for the garbage trucks to collect. Courts have ruled basically that once garbage is placed in those garbage bins and rolled out to the side, even if the bin is still on the person's property, it's still within the property lines, it has been argued, well, wait a minute, if the garbage bin is still on the defendant's property, police don't have a right to search that stuff. The property owner has a reasonable expectation of privacy to the contents of that garbage bin, and the courts have ruled no, they do not. And the reason they have ruled that way is they basically said that once someone leaves their garbage out to be collected, even if that garbage is still on the homeowner's property, even if it isn't on a public street, it has still been left out there with the intent to be collected by the folks who do garbage collection in that area. And therefore, once that intent to leave it out there for the world to see, for animals to dig into, for maybe homeless people to rummage through. And again, I'm not making a joke here. These are actual scenarios that have come up in court. Hey, when you leave that garbage out, you're leaving it out basically for the world to go through, whether it's a homeless person, a dog or a cat, or a raccoon, or a garbage man, or the police, because again, you no longer are basically saying, this is my property. I have an expectation of privacy to it. You're basically saying, I'm leaving this garbage out to be collected. I don't care about it anymore. And lots and lots of folks who have been caught themselves in drug defense cases, either drug trafficking, possession, or selling cases where they have thrown away scales with residue on it, drug residue, or they've thrown away other paraphernalia like little baggies, dime baggies, or bags that would normally be used for small amounts of drugs to be sold, whether it's marijuana or something more illicit. That they throw this stuff in the garbage, they forget about it, they forget it's in there, and then again thinking, hey, if I leave this on my property, the police still can't search it because it's on my property and they won't come and grab it or anything. Oh yeah, they will, because again, courts have said that if you leave it out there to be collected on garbage day or even the day before garbage day, and you don't bring it back in the house with you at night, then you have no reasonable expectation of privacy to the contents of that garbage bag or the garbage canister within which those bags are located. And even though the police can't see inside them, again, getting back to the plain sight doctrine, that means they would otherwise need a warrant. That's not the case when it comes to garbage. So keep those things in mind as you think about the Fourth Amendment. Now, when you think about stakeouts, again, it's usually it has to be off of the individual's property because they won't have that warrant yet. They're trying to get evidence so they can get that warrant. So they'll do a stakeout again, either in the neighbor's home over here to the west, or to the golf course to the east, or maybe in the tree line to the north. Or they'll just kind of drive around a lot and kind of observe the home that way. They'll use unmarked cars and even police cars to report. They're going to drive by at least 5 times a day. It's not going to be suspicious because the people aren't looking out 24/7 to see and mark which cars go by and when. So they may not notice the suspects inside the home may not notice that car is driven by 5 times, or that there've been 3 unmarked cars and 2 marked cars that have driven by. And again, they will then record anything that they see, the cars in front of the home, the license plates on those vehicles, people going in and out of the home. What are they carrying? What do they look like? Are they known suspects in other crimes? All of these things they will use to kind of rack up points towards getting to that nice, beautiful, golden point where they want that probable cause, that reasonable suspicion. They've got, the person left with laundry bag, with a bunch of duffel bags under their arms and got into a car and drove away. That's a point. Then they'll observe people going in the home with nothing and leaving with big duffel bags. That may be another point. And as they continue to collect evidence, and again, I'm making up the point system, but the point I'm trying to make is that as you collect evidence, you're getting closer and closer to that threshold that you'll need to convince a judge that a search warrant is needed. And that's what police will do when they conduct a stakeout, or when they do drive-bys of a home and observe the home that way. Or they'll just simply ask neighbors, do you notice things at that home at night? Now, sometimes they won't involve neighbors because sometimes the neighbor knowing what the person does, maybe they know that they're dealing drugs out of their home. And so they may go over and tell them, hey, the police have been asking about you. And then once they know that the police are kind of onto them at that location, they just move locations. They'll clean everything out. They'll strip the home of any evidence, and then they'll move their operation to another home. So the police do have to be careful about, conducting these stakeouts or searches or talking to neighbors. Because again, if the defendants notice that the police are watching, then they'll obviously pick up and go. And the police can't just jump into action at that point and raid the home. Now, sometimes if they think they've got enough evidence to get a warrant, they'll then try and get a warrant before the people leave so they can raid the home. But they can't do it immediately. Again, they cannot do it without a search warrant when it comes to a home or any place where a person is residing. It could be a hotel room, by the way. It can be a tent at a camping ground. It can be a box on the side of the road if the person's homeless and living in a box. That box is their home. So all of those things play a role and are considered homes or places that require a warrant before they can be searched when a crime is suspected. So again, you've got a search warrant that needs to be written with particularity with regards to the things to be searched and the items to be seized before a home can be searched. And when it comes to cars, they need either the person's consent to search something that they can't see the inside of, i.e. a trunk or a glove box, or they need probable cause to continue conducting that search. Now, quite often with traffic stops, let's assume it's a situation where the police suspect that the person driving the vehicle has large amounts of marijuana in the trunk of their car. Now, we remember what we said about car trunks. You can decline a search there. If the officer can't see inside whatever compartment it is, then the plain sight doctrine doesn't apply, and the officer would need another level of probable cause to conduct a search. And what they will do is they will seize the vehicle, tell the driver he's not free to go, and they will call in a canine unit. The canine unit will then show up and do a walk around, and if they smell drugs, the dog usually has some sort of sign they will give to the officers that tell them that the dog thinks that there are drugs in the car. And courts have ruled that that is enough. That is enough probable cause to open that trunk, to get the person out of the vehicle and conduct a more intensive search of things that they cannot see inside the vehicle, like the trunk and the glove box and the center console, things under the seat, and so on. However, in the United States versus Rodriguez, a 2015 case, the U.S. Supreme Court ruled basically that officers cannot seize a person for a traffic stop. Let's say they pulled them over for speeding, and then they're like, well, you know what? I have a hunch there's something in that trunk, and the driver won't consent to a search, even though I've asked them several times. They must have taken Professor Morris's class. So I'm going to hold this person and call in a canine unit. And I was just notified that the canine unit it's going to take them half an hour to get here. I'm just going to keep this person here for half an hour until the canine unit shows up. Well, the Rodriguez court basically said no. The U.S. Supreme Court said that officers cannot seize a vehicle or a person for an extended period of time while they wait for a canine unit to show up so that they can conduct or get more probable cause to conduct a more detailed search of the vehicle. That is, look inside the trunk or other areas where they cannot plainly see. And so that is a bit of a balancing test, again, that officers have to take into account when they are when they're conducting a vehicle stop. Usually what happens is either the driver is intoxicated or the officer believes reasonably that they're intoxicated, and that gives them a reason to do a field sobriety test. And while this field sobriety test is going on, then the canine unit is on the way to do the walk around, and that is probably going to pass muster. However, again, even if that dog walks around and gives the high sign that there are drugs in the vehicle, and that, yes, that gives them rise to open the trunk. If they find drugs in the vehicle later, that can still be challenged under, again, a Fourth Amendment right violation. So make sure, again, if you are the police, that you are not holding this person longer than is necessary in order to conduct a field sobriety test or to question the individual more. Maybe there's a horrible scent of marijuana coming from the vehicle, and the officer is pretty sure there are drugs in the trunk, and they can use that smell coming from the vehicle to, again, bump up the probable cause and try and get that trunk to get opened. But they'll usually call a canine first, since if the officer is just acting on a hunch, that's not enough. You really need to articulate, again, articulable suspicion. They need to be able to explain why they had probable cause to believe a crime was committed. A hunch isn't enough. I smelled the strong scent of marijuana coming from the vehicle. Great. They're going to call in another officer then. Do you smell the marijuana coming from this car? Absolutely. Okay. Then they may have enough to ask the driver to step out, and they will conduct a search of the trunk. But they are taking their chances because, again, they really want a canine to sign off on that first, because courts have shown that canines, because they have such great abilities to smell drugs when they're properly trained, that evidence is admissible when a canine is signed off on it. And when I say sign off, they have done a walk around, and the canine has signaled to the handler that yes, they believe drugs are in the car. Usually they'll lay down, or they'll raise a paw. There's some sign that the handler and the dog will have that only they know, that will tell the officer that the dog believes there are drugs in the vehicle. So it is complicated. Sometimes it really can come down to a very the officer did this versus that, and that can sometimes get evidence admitted, or it can sometimes get evidence dismissed. And the best way to learn more about the Fourth Amendment is to read case law on this. And again, whether you're an aspiring police officer or an aspiring paralegal, I encourage you to read some cases. I will probably link a few cases in the lecture, this week's lecture, to allow you to read those, but I'm not going to require it. It's not testable material. What is testable is what's contained in this lecture, some of the videos I'm going to link along with this lecture, and maybe a few other items. But the cases, because this isn't a law school class, I'm not going to force you to read case law, because some of that stuff can get a bit dense. But the Fourth Amendment cases are interesting, especially the ones involving drugs, because, again, it usually is a very fine line between what's admissible versus what isn't, when police are especially conducting traffic stops, because some courts have ruled that strong scent of marijuana is enough to allow an officer to search the trunk of a car. However, other courts have ruled that you need an intoxicated driver and the strong scent of marijuana. You need and a canine to sign off or to signal that marijuana is in the vehicle. Officers, when they really want to lock the case down and make sure that they are protecting the evidence that they are collecting from Fourth Amendment challenges, is to get a canine involved. And if you've ever driven by a vehicle that's been stopped and there's like 5 police cars around it, and the car is stopped and it's not going anywhere, that's usually a drug search. That is usually a situation where the officer has called his sergeant and maybe even his or her captain out to the scene to kind of sign off on these searches, so that everybody's on the same page when it comes to who decided to do what and when it came to searching these vehicles, because they believe that they've got a big fish, or they believe they've got a big drug bust, and they want to make sure everything is done properly. Because, again, if you violate any of these Fourth Amendment rights, or if you're a suspect and your Fourth Amendment rights are violated, any evidence that is collected in violation of those Fourth Amendment rights can be excluded by the court at trial, and that can get a case dismissed, and that can obviously, if not get a case dismissed, can at least get the case can get a not guilty verdict. So you, again, if you're an officer, you want to be very careful with how you collect evidence. You want to keep the Fourth Amendment in mind always. And if you are a paralegal or even just somebody driving around at night, especially late at night, you want to, and you get stopped, you want to make sure that you understand your Fourth Amendment rights and what those limitations are when it comes to searches and seizures of a vehicle, and the limitations when it comes to searching and seizing things from a home. So we will end it there. And again, if I apologize if I went a little bit off base there with some of the, trying to establish a point system for search warrants. That's really not how it works. But in my head, it does. And again, it is basically collecting, again, enough evidence to obtain that sort of magic line where there is enough probable cause to either get a search warrant, or if it's a vehicle, to search things that the person hasn't consented to, like the trunk or a glove box or a center console. Anything they can't see with their plain eyes, smell with their nose, or hear with their ears. Okay, so have a great day, everybody. We will talk again soon. And if you have any questions, as always, let me know, and I'll be happy to get back with you. Take care.